All right, is there anything you all want to say in mitigation of punishment?
Judge, would it be all right if I remove my mask briefly?
Yes.
Judge, I briefly wanted to address the court on Mr. Martin's behalf. Judge, like yourself, I've dedicated my life to attempting to seek justice through the jury system, and we believe in this case the jury did not get it right. We believe justice was not done. We did approach this court to ask the court to set aside that verdict and order a new trial. Your Honor has ruled against us in that matter. And now we plan to go on to the Kentucky Supreme Court, and it is our hope we will prevail there. That's what I wanted to say, Judge.
All right. Is there any legal reason why sentence should not now be imposed?
No, Judge. No.
All right. Mr. Martin, as you know, this matter was brought on for trial by jury beginning the 2nd day of June 2021 through the 17th day of June 2021 on a change of venue in the Hardin Circuit Court. And you were present throughout those proceedings with your attorneys. And the matter was presented to a jury which returned verdicts of guilty on 3 counts of murder, 2 counts of burglary in the first degree, 1 count of arson in the first degree, 1 count of criminal attempt to commit arson in the first degree, 3 counts of tampering with physical evidence. The jury imposed sentences of life in prison without the possibility of parole on each of the murder charges, 20 years on each of the burglary first-degree charges, life in prison on the arson first-degree charge, 20 years on criminal attempt to arson first-degree, and 5 years on tampering with physical evidence in all 3 of those counts. Under Kentucky law, the fact that your offenses involved the use of a firearm makes the sentences violent offenses, the murders at least violent offenses, and you are not eligible for probation. Therefore, it is the judgment of this court that you be sentenced accordingly as I have described the jury verdicts. And those sentences will run concurrently for a total sentence of life in prison without the possibility of parole. You are continued in the custody of the jailer of Christian County until such time as the Kentucky Department of Corrections determines where you will be incarcerated. All right, thank you.
Judge, may I ask, will this order be entered today?
Yes.
In that case, Judge, I have some appellate documents I would like to file.
Very well. You are entitled to appeal the court's judgment, and you have 30 days to do so. Apparently, your attorneys have already seen to the importance of that and filing the paperwork now. Will you all be continuing to represent him?
We're asking that DPA be appointed.
All right. Do you have an order to that effect?
Yes, sir. I've got a motion. Here's the notice of appeal. I have a motion and order granting informa pauperis status.
Okay.
And then I have the designation of record, which includes today's proceedings.
Very well. So ordered.
The IFP order, in fact, appoints DPA.
Yes.
Okay.
Judge, there was one other matter I wanted to to raise, and I'm not sure procedurally how Your Honor usually does it, but we are asking that the evidence in the case be preserved, given the possibility of post-conviction relief.
All right, well, if you want to tender an order to that effect, I'm confident the evidence will be preserved as it typically is and always has been, but just out of an abundance of caution, if you want to preserve that issue by tendering an order.
Your Honor, Commonwealth would not object.
Yes, ma'am.
And, Your Honor, the Commonwealth requests that 2 family members be permitted to speak.
No, ma'am, I don't believe that's necessary. The court was well informed about the family's position when they testified at the before the jury deliberated on sentence. And plus, I will say for the record, the PSI report in this case is the most comprehensive one I believe I've ever seen. And I have read each and every letter that was submitted by a family member. So I'm pretty well versed on how they feel. And I think I'm well advised to deny the request that they address the court at this time under the circumstances. But let me reassure them that their letters have been carefully considered.
Thank you, Your Honor.
All right, thank you. All right. I think that takes care of business, gentlemen. Mr. Martin, you're remanded. Thank you.